Hello, welcome to another episode of Frontside Press. I got to go to the glasses here. I'm getting old and I can't read jack squat without them. So, welcome to another episode of Frontside Press. I am your host, one of your hosts, Musings with MGL. And as you probably can tell, our second host, Mike, is not here. He made it approximately 2 shows into our new project before he had to not appear for a show. Actually, he has his company Christmas party is tonight, so he couldn't make it. That's one of the benefits, though, of running your own business like I do. You can set your Christmas party whenever you want, and you don't have to worry about it. Another person who has that luxury is the guest that is joining us tonight as our guest co-host tonight, our guest of honor. You probably remember her, and you know her, and you love her as our wonderful resident expert in firearm law, similar to myself, as well as elder law. Welcome, Cindy Clark, the Minnesota elder law lawyer. How are you doing?
Good, Jeff. How are you?
Excellent, excellent. Yeah, we haven't done a show. Obviously, we were always on the first Tuesday of the month, back when we had the in-studio show. And then, as we said last week, the show kind of shut down for a while for various reasons, and now we're kind of restructured a little bit. So we plan on having you back on a regular basis, just like we did before, once a month, whether it's the first Tuesday or third Saturday, whatever we end up doing. But you filled in at short notice. I reached out to you last night. You said you'd be happy to do it. So thank you for filling in at the last minute for our absentee host.
You're very welcome.
So what's new with you? Anything exciting going on in the legal elder world these days?
It's kind of a funny thing. So I do elder law, but really I do estate planning. So, wills and trusts and powers of attorney and all that good stuff. An occasional probate here or there. But yeah, there's really not a whole lot new in estate planning.
Yeah, they haven't changed how people die and their stuff gets divvied up for decades now.
Yeah, it's pretty much the same, although it is funny how people are always shocked that when they die, their stuff doesn't just automatically go to their beneficiaries. They think it just magically transfers somehow. We had a gentleman today that couldn't figure out why he needed somebody to sign the forms to dispose of his body when he died. Yeah, funeral homes don't do that without somebody signing. They need somebody to sign the paperwork. And he wanted to know if we would do it. And we're like, no, that's not what we do. But
well, I mean, I guess if somebody dies... Yeah, mortuary school. If somebody dies and doesn't have, I mean, it wouldn't matter to you because you're a state lawyer or whatever, but I guess if somebody dies and doesn't have relatives or family and hasn't designated any of those people, what does the morgue do then, or the mortuary do then? Just whatever they want?
Well, what happens, this gentleman actually had prepaid for his burial or cremation.
Sure.
So he had been to a funeral home and had already prepaid, made his arrangements, all of that. His problem is he has no people. He has no family, no wife, no kids, nobody. He's got a brother who he said he can't trust or can't rely on, let's say. And so what happened is he thought he was all set. And then the funeral home's like, well, no, when you die, you need somebody to sign the paperwork so that we can take your body from the coroner or the morgue or the whatever they call that place now, and do what you paid us to do. And then they still have to get to wherever the body's going and all that. But anyway, so he was very confused by all that. But what happens is, I actually know this because this happened. If your body isn't claimed, so they do try to reach out to next of kin. They usually involve police to see if there was anybody at the location that they found the body, anybody on the driver's license as an emergency contact, things like that. So they do try to find next of kin. But if they don't find next of kin within a fairly short period of time, I think it's like 2 weeks, then basically the county considers it an abandoned body and arranges, if they don't know if there's any assets or anything like that, then it's normally a pauper's type disposition. Now this guy already prepaid, so they had a place to plant them. But
I would imagine there's a certain amount of money set aside in government budgets or whatever to bury unclaimed people, homeless people, or whatever people they can't find. I would imagine,
There are every county has a certain amount of money put aside for it, and then of course if assets are discovered,
they can make a claim
then
on the
the
estate or
county
something.
can get paid back, right? Yeah, it's kind of a creepy thing. And actually, I did find out something else too, that there are people that actually donate money for this purpose. They donate it to the county to help pay for people who can't afford it.
People's funerals. Interesting. I would imagine San Francisco must pay billions of dollars a year in unclaimed homeless people's bodies. They probably just leave them on the street for God knows how long. All right. Well, that's a morbid way to start the show tonight. Let's switch to the typical way that we start the show with a toast. I went ahead and did some research and found one that I think would be appropriate tonight. It's about absent friends, because our co-host decided to absent himself from the show tonight. So we're going to do a little toast about what it means when people can't be where they're supposed to be committed to be. So, I don't know if you have a glass, but I'll raise one anyway. Here it is. Everybody get your glass. Get ready to drink. Speak kindly of your absent friends to those that are present, that they may not think you are unmindful of themselves when they are absent. Toast. Absent friends. That one is for live friends. There's other ones out there when people are dead. And Mike's not dead, I assume. So he's just not here tonight. All right. So tonight, we teased a little bit last week that we were going to talk about a topic that's kind of on a lot of people's minds. Probably a week doesn't go by that I don't get a phone call or an email or an inquiry about this topic. And I don't have a lot of answers for people because there's not a lot of information out there about what's going on with this particular issue. So we're just going to jump right into it. And what we're talking about is this new point system for stabilization braces. So I'm not going to spend a lot of time giving a background on what stabilization braces are, because most people who are watching this show probably already know, and I'd factor that a huge percentage of them probably already have firearms with stabilization braces on them. But for the lay person, it's essentially a little brace that goes on the back of like an AR pistol or some sort of rifle that's used normally a rifle, but it's got a shortened barrel, so it's pistol because it doesn't have a stock on the back of it. So a while ago, they created this little brace that goes on the back of the pistol that straps around your arm. Long story short, it was designed for people who came back from war, who were maybe amputees or whatever, and only had one arm and couldn't really fire a rifle anymore. So it's a stabilization brace that goes on their arm so that they can shoot a pistol that shoots rifle caliber rounds without having to use the other arm. So people found out real quickly that you could put those on the back of a AR pistol, and it almost turns it effectively into a short barrel rifle, but because it's not an actual stock, there was the argument that it's not a short barrel rifle, so I don't have to pay the $200 tax stamp and register it with the federal government. So the federal government didn't like that. The ATF, a lot of anti-gun people didn't really like that because they felt there was some sort of a loophole workaround to the whole short barrel rifle rule. And so there's always been this pushback against these stabilization braces because the ATF just doesn't like them because, again, they think that they're just a workaround for the rule. And so over the years, various things have happened with these braces. ATF has issued letters or advisory letters or whatever they were called that would say whether something is allowed or not around. Or originally they said you couldn't have them, but then they said you could. You just couldn't put them on your shoulder when you shot, and then somebody would manufacture a new one that had a little bit of a modification, and then they'd issue another letter. And there's been this kind of mass confusion, for lack of a better term, over the last, I don't know, what, 7 or 8 years since these things have existed, about whether they're legal, not legal, or are you allowed to have them, not allowed to have them, what happens with them. Essentially, they've been legal because, again, there's no specific rule that outlaws them, and the ATF had been hesitant to pass rules or outright ban them because they're so popular and so many people have them. But now, all of a sudden, back about, oh my God, it's almost been probably, 6 months or so, or even more now, since this first came up, the ATF proposed a rule change that says they didn't outright ban the stabilization braces, but they created a point system, which basically means they take features of the firearm and add them up and see how many points they are. And if they're more than a certain number of points, you can't have the firearm without having a tax stamp. So that being the background, take it away, Cindy. What do you think about? What do you know about that? And inform our readers, or our listeners, I guess I should say, of what you know about it, what the form means, what the point system's like, and what do you think about all this nonsense that they're trying to do?
Well, so
loaded question, I know.
it is nonsense. Yes, it's definitely a loaded question, and there's a lot of questions in there. But so obviously the whole thing is nonsense, but we'll just gloss right over that. So the whole idea, I mean, as we know, and as you just said, the idea is that people will always find a way to try to get around the rules. That's number one. And number two, all right, I got to step back a little bit because
Sure.
I need to talk about why short barrel rifles were ever put on the NFA to start with.
Yeah.
So if you think about it, what happened? This was back in the 1930s. And this was during the time of the Al Capones and the Valentine's Day Massacre and bank robbers. And I mean, it was just a crazy, crazy time. And it was Prohibition. A lot of it was due to Prohibition. And so gangsters, the old-fashioned gangsters, not the gangsters we have now, their weapons of choice tended to be Tommy guns, fully automatic machine guns, silenced weapons of some sort, pistols with suppressors, things like that, and then sawed-off shotguns and sawed-off rifles. And the idea was, of course, that they could easily conceal them. They'd wear a big trench coat or something, or even just a suit jacket, and could conceal these things, walk in and shoot down everybody. Okay. I mean, that's how they were portrayed. Let's put it that way.
Sure.
So Congress, in their great and Wizard of Oz type of wisdom, decided that they needed to stop this. This was not good PR for people just to be shooting each other in the streets and in restaurants and this, that, and the other. And the mass crowds were frightened. So politicians, in their usual way, think they have to solve a problem with more laws. So what they said is, well, then that first dead instinct. I mean, that was the first instinct. And when you look at the actual testimony in Congress, there was actual written testimony, and you can read it. That's the first thing they wanted to ban all guns, except they begrudgingly said, well, maybe not hunting rifles. Okay. But they wanted to ban handguns, all these other things. Well, luckily, enough people in Congress still had some sense, and they said, no, you can't do that. We have this weird little thing called the Second Amendment. It's never really been proven in court, but we're pretty sure it says you can't just ban guns. So, and they said, and you certainly can't ban handguns. There's just too many people that like and use handguns. You can't do it. So anyway, what it ended up saying, okay, well, we're going to ban sawed-off shotguns, sawed-off rifles, because nobody needs one of those, and they're just used by bad people to do bad things. And of course, fully automatic machine guns, only bad people would ever use those, so we've got to ban those. And then, of course, suppressors, because the only use for a suppressor is to hide the fact that you shot somebody, because, they're silent. In theory. But anyway, so they got enough support to get these things on the national firearms list. They had to kind of do what the Obamacare did. They had to, first they were going to make everybody register all these weapons, actually all weapons. But again, the Supreme Court struck that down. So what they did is they said, okay, then we're going to require a tax. And the Obamacare people took learned from this and used that to get Obamacare approved through the Supreme Court. But anyway, so they said, well, it's going to be a tax. And the way they came up with the $200 tax for these weapons is, at that time, that was the retail price. It was a lot of money, but it was the retail price of a Thompson machine gun.
Oh, there you go.
So just an arbitrary number they chose. And so what it did, and that $200 has never changed. So, but the whole point is concealability. That was what they were trying to change. So in the ATF has gone from regulating stills to regulating one of the biggest industries in America, with guns. And they are power hungry, and they just keep making more and more rules. And they don't like when people get around their rules, even though their rules make no sense. So in this particular case, I know I'm going on and on about this, but my point is that if we're really concerned about concealability, then what really is the difference between an AR pistol and a short-barreled rifle? You know what I'm saying? It's all
the point is to not have people see them. Then you would want to ban AR pistols because you're having a rifle caliber gun and something that you could stick under your coat.
Exactly. But I guess they figured out they just can't do that. So now what they're trying to do is make everybody with an AR pistol pretty much have to pay the $200 tax stamp. That does bring in quite a bit of money to the government every year. I don't think it brings in enough to even pay the ATF agents that are having to deal with this. But anyway.
But it's not about, I mean, it is partly about the money. It's always about the money for government. But in this particular case, it's more about the control and the regulation and the denial of the Second Amendment to the citizens more than it is about money. If they didn't make a dime off of it, hell, if they lost money on it, they wouldn't care as long as they could remove the dangerous weapons from the streets.
Well, and that's what it is. So it's all a dog and pony show. It's number one, they want to make things more difficult for gun owners. The more difficult they can make it for somebody to buy a firearm, the happier they are. And this just, I mean, now, like you said, everybody who owns one of these stabilizing braces, or everybody who's thought about getting one, everybody who has an AR pistol is now sitting here going, what the hell? Right. We don't know where we stand anymore. And is that going to stop some people from buying an AR pistol, number one? Okay, just because, oh, I don't know. How do I know that it's just an AR pistol? Maybe it's really a short barrel rifle and I just don't know enough. I mean, Jeff, you know a lot about guns, and my husband does. But personally, me, while I know the laws, I wouldn't know really to look at a gun what kind of stock it has for the most part. You know what I'm
Right.
saying?
Sure.
Um,
Hmm.
so and I think the average person is probably more like me than like you and Tim and Mike and everybody else that, so they'd be afraid to get on the wrong side of the law. And so they may just say, oh, well, I don't know. I'd really love to have one of these AR pistols, but you know what? I'm going to go get a Glock. I know what
Right.
that is. I don't have to worry about it. Or I'll buy an AR-15. So anyway, so it's just an aggravation factor. But the other thing that you and we were kind of talking about a little bit earlier, um, if I guess maybe we should have Carrie put the screen up with the factoring criteria on there.
Yeah, that's fine. Nope. Nope. You're good. Yeah, let's go ahead and put up.
Um,
So this is the new. So this is the form. So just a little background before we put it up. As we talked about, the ATF has now come up with this point system. Yeah, that's a little blurry. So you see if you can fix that while we're talking. Um, oh, okay, good. So what you're saying is I can't read it for shit, but everybody else knows what it says. Good, good. Good, because I thought for a second I needed a whole new prescription because when I on my screen it's blurry AF and I can't read it. So hopefully somebody will be able to walk through it. So here's what happened, and the easiest way to describe it is, they can't just they can't. I mean, I guess they could because they did it with the bunk stops, but for whatever reason they didn't want to just make a rule that says you can't have stabilization braces. And so what they did was they came up with a point system, and as you mentioned earlier when we were talking before we started, the point system is on the backside. So what I mean by that is, in the legal realm, we know of a phrase called we know it when we see it. So it was applied to pornography. There was a case in the 60s. They wanted to ban pornography, and they wanted a definition of what pornography was. And the Supreme Court famously said, well, the definition of pornography is going to be, we'll know it when we see it, which means they couldn't say on the front end that this is pornography. You had to make the pornography. They would look at it on the back end and they would go, oh, now that you've made this pornography, it's clearly pornography. And so you can't have it. And you could be charged with whatever pornography laws existed in the state that you resided in back then, et cetera, et cetera. So they're doing the same thing with the rifles. They're not putting out a rule on the front end that says this is definitely illegal. What they want you to do is to build the rifle, short barrel rifle or not a short barrel rifle, I guess it depends on what you want to call it, and then they'll look at it on the backside and apply this point system to it, and then tell you whether your rifle is a rifle or a pistol, and whether you need to pay $200 or not pay $200. And so this is why everybody's kind of panicking, because it's really unfair, because you mentioned that a lot of people don't necessarily know what a stock is by looking at it or whatever, but you can have people who even know these things, and they're trying to do the research and they're trying to figure it out, and even they can't figure out if something is going to be legal or not legal. Like I said, I don't get a week that goes by where somebody doesn't ask me, and I don't really have an answer for them right now, because you can't figure out when this law is going to be published. Is it going to be published? What are the point systems going to be? Does my rifle or the pistol that I currently have going to be legal or illegal? Like a lot of people are asking me, and my answer is basically, I don't know. The ATF's policy is send us a picture of what you've built already. We'll look at that picture and we'll tell you whether you need to send us $200 or whether you don't need to send us $200. And the rule is supposed to contain an amnesty period in it, which means you have a certain amount of time to do that, or we're going to come get you because now we know you have an illegal rifle because you sent us the photo and we already said it was, and your amnesty period has ran out, so now they know you've already committed a crime because you've sent them the photo. And so they're not telling you on the front end, and then going forward, you're going to have to try and sit down with all the parts not put together and try and add up the point systems on the form and then decide whether you can put the parts together or not put the parts together. So it is a ridiculous concept that is not just going to discourage your layperson who doesn't know what they're looking at. It's going to discourage a lot of people who do know what they're looking at because they can't figure it out. So it's really a pain in the ass.
It really is. And Jeff, I do have a clear form on my monitor here, so I can see all the points and different things. But it's and again, as Jeff pointed out, this rule has not actually gone into effect yet.
Right.
And there's some question as to whether it is actually going to go into effect. So we could be worrying about nothing, but honestly, I never feel like it's nothing under the current administration. They are going to try to get something through. But yeah, some of these things, I mean, my guess is the reason they didn't outright ban stabilization braces is due to disabled people. That would be really bad PR to discriminate against our war veterans. That would not look really good. Didn't
so is the form ban. I don't see the form on my camera. Is the form up for the people to see? Yeah, put up the first page where it starts with section 1. Yeah, I'm not going to be able to read it, but I do have a clear version on my screen. So if everybody at home can see the clear version, that's fine. Yeah. So here's essentially how it works. I'm going to run through it a little bit to see if we can figure it out. So section 1, prerequisites. The weapon must weigh 64 ounces. The weapon must have an overall length between 12 and 26 inches. Weapon must meet both prerequisites in order to proceed to section 2. So if you take your thing that you've already built and it's less than 64 ounces and your barrel length is not between 12 and 26 inches, then you don't have to worry about it. Or actually, no, I think it's backwards. You do have to worry about it because that means you can't have it. And the way these things are, if you read, there's section 1, section 2, section 3. You basically you have to go through one section. And if you clear that section, then you can go to the next section. And then if you clear that section, then you can go to the next section. And each section has their own set of points. So as you can see, section 2 starts with the accessory characteristics. And at the bottom of that, it says section 2 must score less than 4 in order to proceed to section 3. So if in this first section you already have 4 points, you're done. Your firearm is illegal. You need to get a tax stamp for it. If for some reason you survive this first section, then there's a section 3 that has a whole bunch of other characteristics. And at the bottom of that section, it says a score of 4 points or more indicates a shoulder fire design. So this section also, it has a 4-point minimum. So each section separately has to be less than 4 points. If it's not, you need to have a tax stamp and your firearm is illegal. And some of the things on here are pretty simple. For example, accessory design, not based on a known shoulder stock design. I don't even know what the hell that means. Incorporates shoulder design features. Again, I don't know what the hell that means. I mean, at that point, one of them paddle things could technically incorporate a shoulder stock design feature because you can theoretically put that on your shoulder and shoot it. Again, another one based on a known shoulder stock design. Well, do we all know do you have a list of every known shoulder stock design that exists in the world today? How are you going to figure that out?
Well, but if it is, you've already scored 2 points.
Right. That's the problem. If it looks anything like a known design, you're already at 2 points. And again, what is incorporates shoulder design feature? You could argue that anything incorporates a shoulder design feature, other than possibly a buffer tube, because nobody probably would be able to argue that, although some idiot at the ATF might. But anything, even like I said, even those paddles have flat surfaces on the side, and so anything could theoretically incorporate a shoulder stock design feature. It's so open to interpretation. Who knows? Minimize rear surface, lacking features to discourage shouldering. What does that mean? Rear surface, useful for shouldering the firearm. You could argue that every rear surface in a stabilization brace has, because if anybody's seen the stabilization brace, they all have a flat end on the back. So the rear surface is obviously useful for shouldering the firearm. Material added to increase rear surface for shouldering. So a lot of those braces have little rubber pads on the back. If they've got a little rubber pad on the back, that is material added to increase the rear surface for shouldering, and that already gives you 3 points. If it's not adjustable, you get 0. If it's adjustable or telescoping, you get 2 points. So if you have a brace that has any sort of padding on the back and is telescoping, that's automatically 5 points and you've failed. So that's a huge percentage of the braces that exist out there have some sort of padding on the back of it and are telescoping, and you've already failed. If you have that brace design at all on your firearm, you're done. It doesn't even matter. Just look at the words they use. Counterbalance design that folds, creating rear contact surface. So if you have any of those folding ones, that gives you a points. A fin type design with an arm strap gives you 0. If you have a fin type design without arm strap, that gives you 2. So let's say you have a fin type design that gives you 2, and then you go back up here on the top that says it incorporates a shoulder stock design feature. I would argue that they could say that as well. Now you're at 3 points. So that's ridiculous. Cuff type design that fully wraps around arm, 0 points. Cuff type design that partially wraps around arm, 1 point. Well, that's all of them are designed that way. That's the entire purpose of the stabilization braces that we talk about, is the strap goes around your arm to hold it. If it only partially goes around your arm, you get a point. If it's not long enough to go all the way around your arm, you get 2 points. So you can see it's real easy to get up to 4 points on this first section. The bigger problem, though, is the second section. And here's why. I don't know if that's on that first page because it's blurry or not. If it's not, then you might need to go to the second page where it starts with section 3, configuration of weapon. Okay. So we need section 3, configuration of weapon, which is probably on page 2. It's a little boring tutorial, but it's important to kind of get it out here. So the problem with this section is the top part, length of pull. So as you see, it's got a bunch of different lengths of pull categories on here. Now that obviously is from the trigger back to the rear of where the stabilization brace ends. Now, you and I did a seminar recently at a local gun shop because we travel around all the local gun shops and do these gun seminars. After the seminar was over, I stayed with the owner of the gun shop and their gunsmith who hangs out or works there basically. And we pulled every single firearm off the shelf and got out the tape measure and did this length of pull. They didn't have a single pistol, AR pistol or AK-47 pistol or anything on there with a stabilization brace on it that didn't get you 4 points. They didn't have a single one because that's not how they're designed. The minute you add a brace to the end of those, it creates a length of pull for everyone they had that was over 13 and a half inches. So that gave them 4 points automatically. And even if it's a little shorter than that, you get 3 points, you get 2 points. So just the length of pull on the firearm, not even doing anything with the straps or any of the stuff that we talked about in the other section, they were over the 4 points, or they were at least more than halfway there with 3 or 2 points. So the length of pull always got you either over or automatically high. But even if you're a little under, let's say you only get the 3, when you go down here, look at the attachment methods. If you attach it with a buffer tube, you get a point. If it's an adjustable rifle buffer tube, you get a point. If it's an extended AR type pistol buffer tube, you get 2 points. If it's a modified shoulder stock with the rear replaced by the stabilization brace, you get 3. So you got the length of pull, and any way that you attach it to the back of that firearm is going to get you one of these points. Boom, you're over 4 points. Look at the stabilization brace modifications. Cuff type or fin type design with strap too short to function. Well, who's going to determine that? If you got a fat guy arm, maybe it's too short to function. But if you have a skinny guy arm, it'll probably function. So who's to say whether it's functionable or not? If the strap is made out of elastic material, which most of them are, if you've ever seen a stabilization brace, it's an elastic kind of material. Why do you think it's an elastic material? To accommodate different size arms. If you have a small arm or a large arm, you have to have an elastic material if you want the thing to work on more than one shooter. But look, you get 2 points for that. If there's no strap, you get 4. And again, brace accessory modified for shouldering. Who's going to make that determination? Who's the guy that's going to look at that and say, I'll know pornography when I see it, and claim that your accessory was modified for shouldering? And then if you put any peripheral stuff on there, let's say you put a hand stop on it, or a secondary grip, or flip up sights. Look, you put flip up sights on your AR, you get a point for that. On your pistol, you get a point for that. Or look, presence of rifle type backup, flip up sights, or no sights. So if you have no sights on your gun, which would make it harder to aim and shoot people, you get a point for having no sights on your gun. How does that make any sense? Makes absolutely no sense. If you have reflex sight with a magnifier on it, you get 2 points. A scope on it, you get 4 points. So you cannot, if you look here, presence of a sight scope with eye relief incompatible with one-handed fire, which basically means if you put anything on it other than basically a red dot, you're going to get 4 points. Because the theory is that if it's truly an AR pistol and you're not using it for long-range shooting, then you don't need a magnifying scope or a eye relief on it. So you can't put anything on, even if you have no points up here or you're somehow under the number, you slap one of those on there, you're done. And then if you put all those things on there and your firearm weighs more than 124 ounces, 4 points, you're done. So again, we pulled off probably a half a dozen things off the shelf and added up all these points by measuring everything, and there wasn't a single one of them on the shelf that would be legal according to this point system. So they've essentially, without actually doing it, they have essentially outlawed stabilization braces, because there is my consensus is, based on my own experimenting, based on the shop, and I've also reached out to several other lawyers in the Second Amendment community, and we had a discussion about it, and the consensus is from everybody that if this point system passes, it is in effect a de facto stabilization brace ban, because it is logistically impossible to build something with a stabilization brace that is not going to put you over the point system. And that's insane.
Yeah. That's the government.
Right? I mean, it's ridiculous. Right. And it's not even a law, because I know Mike always gets mad on this because he yelled about it last week. Well, who are these people? Are they laws? It's not even a law. It's a regulation passed by a bunch of unelected bureaucrats that are essentially going to ban a product that is currently owned by millions of people in the country. And this is why people are freaked out about it, because they can't figure out the point system. It's so open to interpretation. People already have these sitting in their safes. And so when the rule passes, they effectively become criminals overnight, with the exception of the fact that it does contain the grace period. But it's a disaster waiting to happen if this gets passed.
Yeah, no, it is. I don't even know what to say. I mean, I suppose you could say, hey, if you're worried, get your tax stamp, and then you can do whatever you want to your gun, and it doesn't really matter. But again, the idea that we have to ask the government for permission and pay a fairly large amount of money, it's yeah.
Right. Well, that's the issue, because obviously, correct. You could just say, all right, well, screw it. I'll pay the $200 and I'll register my firearm. And if I buy future ones, I'll pay another $200. But it's going to do a couple different things. It's going to be so complicated and scare so many people. Like you said, they're just not going to buy these things. Like they're not going to walk in and buy it off the shelf, because they're not going to know what to do with it. It's going to freak out a lot of the stores, because again, they're going to have to figure out what to do. Imagine if you're a store that doesn't have permission to sell NFA items or class 3 items, and now you all of a sudden overnight have dozens of class 3 items sitting up on your wall and in your inventory. What are you gonna do with that? If you've got one in your house, while you're waiting, do you have to take it apart? Do you have to send it somewhere? Can you wait for the tax stamp? I mean, again, there is a grace period, but I think a lot of people might be weary about taking pictures of the gun that they already have and sending it in and asking them, hey, am I allowed to have this or not? That's even above and beyond what you have to do when you originally register it, because you don't usually have to send in a photograph of your firearm. You just fill it out. So it's really freaking a lot of people out. So there's a couple things you can do. If it passes, there will be a grace period, so you can send in the paperwork. The process will be on their website for how to register now and get your tax stamp so you can keep it. You can always disassemble it. So, for example, it wouldn't be illegal if you went and took it and removed the SIG brace from the back of it, or SIG stabilization brace. SIG's a slang term, but if you removed it from the back of it and just separated them, sold the brace or threw it in an ocean or whatever you want to do with it, and just went back to having a regular AR pistol with nothing on the back, or a buffer tube, or even a paddle, you could do that, because there's no reason you can't. So those are gonna basically be your options. Or you could just keep it and say, come and take it, and hope that nobody ever finds out that you still have it, or that you don't take it to the range one day and shoot it, and there happens to be some guy at the end of the thing that gets angry, or happens to be an off-duty ATF officer or something, and then goes down and says, hey, where's your tax stamp? So bad news is, if this regulation gets passed, it's going to be a disaster. It's going to be a nightmare.
Yeah. And well, it definitely, if it does get passed, it's definitely going to be challenged in court.
Right.
It does seem
and again,
like,
when we say passed, it's not a law. When the rule gets adopted
right.
by the agency and becomes published, because you can't say pass, because it's not a law. It's a bureaucratic administrative rule. It's ridiculous.
Right. Well, and so if it's an administrative rule, then there has to be an appeals process.
Right.
But again, who's going to spend the money? I mean, if you didn't want to spend $200 on a tax stamp, you probably don't want to spend the money on an appeals if your weapon is determined by the ATF to be a short barrel rifle. Well, I don't think it actually costs money to appeal. But anyway, it's just super annoying, and
well,
it's harassment.
It doesn't cost you money to appeal, but you're going to want a lawyer to do it, and it's going to cost you money to hire a lawyer, because if you try and go up against the ATF on appeal by yourself, you're most likely going to lose. So it costs you money for lawyers. But look, this is why we have these organizations. So you mentioned that there's going to be lawsuits. There actually already are. So that's all the bad news, folks. So we'll segue into the good news. the good news is there's a growing consensus out there amongst the firearm community and the firearm legal community that this rule may actually never get published and it may never actually be adopted. So a brief little history on it. What happened is when they proposed this rule, they drafted it and put it out there for comments or whatever. It happened before the Bruin decision. As we've talked about before, the Bruin decision is that recent big Second Amendment case that came out with the new conservative, quote, conservative Supreme Court that threw out that bullshit law they had in New York City about needing to prove that you had a reason to have a firearm. And so that case came out after this rule was proposed. Why that's important is because that case, if you want to, why don't you explain real quick what the basis of the Bruin decision was, and then we can apply it to what the new rule is.
I'm having brain freeze right now, Jeff.
Well, I think you always talked about how it was decided on the public interest concept of gun laws.
Yeah. Let me just refresh my memory. Sorry, I am just.
No, that's all right.
I've been so busy lately. Yeah. Dun dun dun. Sorry, it's just been a little while.
You were thrown into the fray at the last minute because
and I should. I mean, this is it's a big law. I just right. Like I said, I've been focusing on other things lately, and I just haven't done that. Looked at this one recently. Well, okay, yeah, proper cause, blah 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 blah. Mm-hmm. Oh, and then how they yeah. Okay. Yeah. Let me see. Sorry, I am just.
Yeah.
Yeah. Talk some more about it.
Well, she's. Yeah. Well, basically, there was just summation. There was the rule in New York City that said in order to get a concealed carry permit, you had to prove that you were in need of it, like a special need. Somebody was stalking you, or you were likely to get killed in the next couple of weeks or whatever. Otherwise, they would deny your permit. And much like most other gun laws, that was based on what they call the public interest argument. In other words, the state would simply say it's in the public's interest to have less guns on the street because the public is more important than the private citizen. And so now you have to have this gun law. They apply that to a whole bunch of other laws as well. And so it's been this long-standing kind of rule that if the government can prove that there was a compelling public interest to passing a certain law, then that law would withstand constitutional scrutiny. In the Bruin decision, my understanding of it is, and again, you can correct me if I'm wrong, the court basically said, no, that standard no longer applies to Second Amendment cases. That's too ridiculous of a standard. It's too low of a standard. The Second Amendment is a constitutional right. So public interest is no longer a compelling reason to have anti-Second Amendment laws. And so that's why they struck down the New York City law. Well, why that matters in this particular case is because the basis for the rule, the entire basis for the rule that the ATF relied on is the public interest concept. So when they wrote the rule, in order to propose a rule change, you have to give an explanation for why you proposed it. Their explanation was the public interest was their justification. And so since Bruin basically threw out the concept of public interest for Second Amendment laws and or rules, the belief is that has changed the game when it comes to this new rule, because the entire justification for the ATF passing this rule no longer exists as a valid reason with the current makeup we have in the Supreme Court. And the Second Amendment Foundation, so back to what started this, was that you can't do it as an individual, but that's why we have these large organizations out there. And the Second Amendment organization actually filed a lawsuit in Texas, I believe. Yeah, there's already a federal lawsuit filed in the court of Texas, which is currently being stayed because it's kind of premature because the rule hasn't been published yet. And it was supposed to be published sometime in December. So that court gave both parties till December 28th to decide whether to continue this stay or to file something on the case, because they're all waiting to see if they're actually going to publish this rule or not. And that's a case that's already existing. And there's already dozens of other lawsuits that have been drafted and are ready to be ready to be filed as soon as the law becomes public. So the thinking out there is that because of that new law, or because of the new Supreme Court case, the ATF basically sees the writing on the wall that the minute they publish this, that Texas case is going to go forward. All the other cases are going to get filed, and Bruin is going to be the controlling precedent, and all of the Trump appellate judges that have been appointed, and then of course you got the Supreme Court judges, that this case, that rule is going to get thrown out basically immediately. There seems to be a idea that if they don't somehow change their justification away from the public interest, that it's going to be immediately tossed out by the first court that it gets in front of, because the Bruin court has clearly ruled on that particular issue. And so there's some other people out there in the legal community who have posted some YouTube videos, some chatter that they have some inside sources that work for the ATF that are telling them that the rule may be basically dead, that the reason they haven't published it yet, because they promised it would be published sometime in December, and here we are already at December 15th, and not only hasn't it been published, they haven't even announced like when it's going to be published, that there seems to be a growing consensus out there that this rule may be dead.
Well, that would be great. Yeah, sorry about the whole Bruin thing, but
That's all right.
But Bruin is a game changer for gun rights. At least it appears to be. Who knows what is down the pike, but as you said, it just raised the bar. They finally said, "Hey, this is a constitutional right, and you have to have a very high bar to infringe on that right." And as we talked about in a previous Front Sight Press, a lot of states, especially New York and some other states, were, after Bruin went through, they were trying to bypass it by going, "Oh, well, then we're not going to say it's in public interest. We're just going to say they can't carry it in public places like Times Square and this, that, and the other." And they had this whole list of places. And that all got shot down, other than in certain similar places we have in Florida, like courthouses.
Sure, standard places, courthouses, sports arenas, schools.
Right. But they couldn't say Times Square.
Right, yeah, or it's the street or any building that has walls. Right, yeah.
Essentially. Yeah, so Bruin, like I said, it seems to be helping get rid of some of these very onerous harassment type of laws that really don't increase public safety anyway.
Right.
So.
Well, and they've been up, and it's been upheld. Like there's a few other ones I don't know them off the top of my head, but there have been a few appellate decisions for some minor gun things here and there that they all seem to be following Bruin. I mean, I'm sure you could get some weird thing in the Ninth Circus Court of Appeals or something that might uphold some weird law or whatever. But the wave is falling constantly in favor of Bruin, and these things are getting struck down left and right. So again, it's not a law, but it is a rule, and like all rules, it's subject to review, even under the Supreme Court, and they've got it, standing. They survived a standing argument because basically anybody who owns one of these is going to be affected. It used to be you'd have to wait until you got charged with the crime, and then you'd have standing, but because it's such a broad rule, they apparently survived the standing, and that's why it's just on stay, waiting for them to publish it because it's not technically ripe. But look, bottom line is, summation for our show tonight is the rule has not been published. It doesn't exist yet. So anybody who out there who's wondering if now, as of today, they have a problem, the answer is no, because the rule hasn't been published. I'm sure once it gets published, I'll make a video on it. So make sure you subscribe to Musings with MGL, give a like, and click the bell for notifications. And if you click the bell for notifications, you'll get a notification when I post a video when the rule gets published. And of course, it'll be all over everywhere else. It'll be on AmmoLand, and any other normal places that you go to will be all over the place. So it will be published. So when it does, you'll know. And again, you won't immediately become a criminal overnight because there is a grace period there to deal with it. But the fact of the matter is, it's a crap system. I mean, it's a bullshit concept. I'll know it when I see it. Like what the hell is? I know it when I see it. So it's pretty ridiculous that you would pass such an open-ended interpretation thing like that for something like this. So it is clearly an affront on the Second Amendment. The bad news is if it does pass, I keep saying pass, if it does get adopted or published, look, it's going to be a problem. Again, I've already given you my opinion, is that it's essentially going to be illegal to have any pistol with a SIG brace or a stabilization brace on it, because you'll never survive that point system. But the good news is it hasn't been published yet. It seems to be like there's a good chance that it's not going to be published. And if it's not, then that would be another huge win for the Second Amendment.
Agreed.
All right. So we were going to talk a little bit tonight about the new 4473 form, but we ran out of time because it was so much fun talking about stabilization braces and pornography and points and math. I went to law school, so I didn't have to do math, and now they're passing a damn rule that says I got to do math. So that pisses me off
only to 4, Jeff. You only got to add to 4.
That's enough. That's enough. But you got to add to 4 like 2 or 3 different times. It's really confusing. So I was told in law school there would be no math. But anyway, other than score sheets, I do have to figure out sometimes how much prison my clients might be doing for the stuff that they got arrested for. So, all right. Anything else you want to add on this topic?
I don't think so. I think we kind of ran that topic into the ground, and all we can do is hope that the rule doesn't get published and doesn't get used, because it would be a nightmare.
Yeah, it's going to be a problem. Like I said, we may have gotten into a little bit into the weeds there, but it's important for people to know, and everybody need to know how the system works and whether it's going on. Because again, I get so many questions about it. Everybody's making YouTube videos about it. It's a hot topic right now. So we just wanted to let everybody know what was going on out there and bring them up to speed. So we're going to end it here. Thanks for watching. Make sure you tune in next week. Remember, we're doing these every Thursday, 8-ish, give or take. Usually it's going to be myself and Mike as co-host. Julie's usually here as well, but we're going to continue to have guest hosts. We're going to continue to have guest people, and Cindy's going to be joining us on a regular basis, probably on the first Thursday of the month, like we always used to do, so we can kind of focus more in on the law. Remember, the other shows aren't just going to be about the law. They're going to be about current events, topics. We didn't get to talk about anything exciting. There were no trades this week for mass murdering gun dealers for basketball players, so we didn't have anything exciting to talk about. But even Twitter's calming down a little bit, so not too exciting out there. So we kind of got a technical show today. But if you want to continue to watch, tune in every Thursday around 8-ish on Frontside Press and Musings with MGL on the YouTube channel. And so for myself and my absentee co-host and my thank you for filling in at the last minute co-host, Cindy, we want to say thanks for watching and make sure you tune in the future. Say goodbye.